Welcome to all to day 2 of Inframarginalism and Internet, conference on markets as wealth distributors and their implications for tech policy. I'm Ramsey Woodcock, professor at University of Kentucky, Rosenberg College of Law, who's been organizing the conference. We've got a great set of panels for you today. We've got this one on redistribution through Antitrust and Consumer Law. Then a little bit later this morning, we have taxation and tech. And then in the afternoon, we've got a panel on antitrust futures. And then we'll wrap up with a great panel asking whether or not we've got a new rent theory in the makings here. I invite you to participate actively through the chat in any of the panels. We'd also love for you to be involved in networking and getting to know each other and other panel participants here, which you can do by using the networking function on the left side of your screen during the breaks to be randomly matched with other participants for short video chats. And then we also invite you to use the function for one-on-one video chatting to catch up with old friends over the course of the conference. And also don't forget to check out our exhibitor booths. We've got half a dozen interesting exhibits, including an original documentary video put together for this conference on the history of Kentucky's 19th century attempt to outlaw profit. So without further ado, I'm going to turn this panel over to Adrian Kunstler, who's a professor on the Faculty of Law at the University of Zurich. Adrian, take it away.
Thank you very much, Ramsey. Good morning, everyone, or good afternoon, or good evening, depending on where you are. As Ramsey said, my name is Adrian Kunstler. I will be your host for this panel, and I'm an assistant professor for competition, intellectual property, and corporate law at the University of Zurich. And welcome to the Inframarginalism and Internet conference panel entitled Redistribution through Antitrust and Consumer Law. So I want to first acknowledge the co-sponsors of this conference, the University of Kentucky Rosenberg College of Law and the John S. and James L. Knight Foundation and Ramsey Woodcock for organizing this conference. Now, you have read the bios of our 5 panelists, and the conference website provides links to their extended bios. So I'll quickly introduce them so we can jump right into our discussion. First, we have Rory Van Loo. He is Associate Professor at Boston University School of Law. Welcome, Rory. Second is Vijay Raghavan, who is an Assistant Professor of Law at Brooklyn Law School. Welcome, Vijay. Third is Birang Kyansat. He is a PhD Fellow in the Faculty of Law at the University of Copenhagen. Welcome, Birang. Fourth is Inge Greve. She is Associate Professor of Competition Law at Tilburg University. Welcome, Inge. And fifth is Luke Herrin. He is the Managing Editor of the Law and Political Economy blog and a PhD candidate at Yale Law School. Luke, welcome to our panel. So as you know, this conversation is on redistribution through antitrust and consumer law, an area on lots of people's minds for a long time now, and certainly for the future even more so as we see an increasing amount of digital technologies pervading our economies. So here is how we will proceed. Each of our panelists will speak for about 9 minutes or so with some introductory comments, and then we will take your questions. I was asked as the chair of the panel to synthesize the panel's various points and to comment on them, and I will take this privilege to ask the first question so that the panel can respond. But then we want our attendees to send in questions through the platform's questions and answer feature, but we ask that you keep your questions concise and on point. So let's begin. We are going to start with Rory, followed by Vijay, Birang, Inge, and Luke. Rory, it is your turn.
Great. So I'm going to share with you today research that I first presented 7 years ago at Brooklyn Law School, actually, and where Vijay is now, but is still relevant today. And what got my attention so many years ago was the fact that taxes redistribute trillions of dollars each year across the economy, And consumer spending also transfers trillions of dollars each year across the economy. Yet policymakers don't pay attention to consumer law when they think about distribution. And so I define consumer law pretty broadly as including both antitrust and consumer protection, just as a basic nomenclature point that may vary for some people. So in particular, what caught my attention is that many companies can raise the prices that people pay by, for example, exploiting the human mind's limitations in decision-making or leveraging monopoly power. And so to examine whether policymakers should pay more attention to consumer law and these kinds of practices in distributional conversations, I looked at three questions in turn. First, what is the size of the overcharge? The overcharge being these inflated prices across the economy. Second, how would inequality change if we eliminated that overcharge? And finally, should we consider using consumer law for distributional purposes? So as to that first question, by how much do consumers overpay in aggregate due to market failures like deception and monopoly pricing that the law might address each year? And so to answer that question, which is really a macroeconomic question, I had to track down a lot of microeconomic studies scattered across consumer protection, antitrust, industrial organization, and all kinds of other fields. Studies like Rebecca Stone and Oren Bar-Gill's findings that people paid 8% more solely because they chose the wrong cell phone plan among a single carrier's unnecessarily complex pricing options. Their related overcharge findings giving the actual percentage of overcharge paid in telecommunications, retail goods, credit cards, mortgages, hospitals, and so on. These studies have their limits, of course, like most economic studies, but I tracked down hundreds of them and then applied them to the national spending figures. And here's what that produced when I adopted a more conservative assumption first, and then just a more direct application of the literature. If you look at the bottom, $1.2 trillion in the base case, $1.2 trillion across the entire economy each year in kind of expected overcharge from these practices. And that's a conservative scenario because it leaves out a bunch of markets that presumably have overcharge, like internet and cable, because I couldn't find a rigorous study estimating overcharge in those markets, even though it's unlikely that cable and internet are actually priced at competitive levels. And so I also looked on the right at, often the studies had a range, and so I would take the higher end of the range or the middle end of the range for scenario 2. To put this conservative number in perspective, this $1.2 trillion, here's the expected, or here's the estimated change in income inequality between 1980 and 2010. And this is research well known by Emmanuel Saez and Thomas Piketty. And the difference between, in 1980, the top 1% of households owned or earned 10% of all income. And then in 2010, that number was up to 20%, so they had a huge gain relative to everybody else. That difference between 10% and 20% earned amounts to about $1.25 trillion. So the pot of consumer overcharge is it's not only in an absolute sense big, but potentially of a magnitude that could matter to macro level inequality. So now turning to that second major question, is this overcharge, if we were to reduce it, of a type that would affect economic inequality? In terms of income earned, I make several assumptions in an area we really just have very limited direct empirics on, but I make those assumptions based on what we do know. So, for example, which internal employees capture the rents that overcharge? If the corporate governance literature and direct empirical studies are right, without strong labor unions, at least, lower level employees do not capture a significant portion of the rents. They may capture some, but not a lot. Top executives, on the other hand, in the top 1%, probably do capture a lot of these rents as income. And I assume in the base conservative scenario that lower level employees, for example, capture about 10% of that overcharge, of that 1.2 trillion. And then the rest is split evenly between senior executives and owners. These are assumptions for a static simulation, really an accounting exercise, if you will. And based on those assumptions, with 1.1 trillion, 50% captured by senior managers and so on, here is the expected share of income based on for the top 1%. So that would lower it from 20% down to 15% if you could wave a magic wand and remove all the effects of that overcharge. Now, in scenario 2, if you have 1.7 trillion in overcharge, you assume senior managers capture 75%. Then again, if you removed all the overcharge, it would lower the share of income for the top 1% down to 10% of all income. So back to where it was in 1980, before we had this explosion in income inequality that's really given rise to concerns about the topic and kind of led to the Occupy Wall Street movement and so on. Now, I'm leaving out in both of these scenarios some factors that could actually make the impact of removing overcharge even greater, like the wealth effects, because over time, it's not just the income in any given year, but over time that compounds because you can invest that income, earn interest, and so on. I don't claim that these numbers are the exact numbers, but the point is that if we try to adopt a more informed perspective, looking at the literature that we do have available, rather than just dismissing consumer law out of some kind of a gut reaction, there's a plausible reason to believe that reducing overcharge would have potentially powerful progressive distributional implications. So now for that third big question, which is whether consumer law might be desirable to use to redistribute. Per Kaplow and Chevel's seminal work, we should prioritize efficiency, and they acknowledge, I'm not saying I endorse that, but that's the paradigm we're often viewing these topics through, and they acknowledge that taxes distort markets. Consumer law, on the other hand, operates by correcting market failures. So at least for some portion of redistribution, consumer law would be a better option than tax law if you're worried about efficiency. Also, there are reasons why consumer law should be considered beyond distributional factors. Besides saving us from this tax inefficiency, it would also be expected to help grow the economy by putting money back into people's pockets who disproportionately would then go and spend it, because low-income consumers spend more of their money than high-income consumers do. When I presented these findings a few years back at NYU at an antitrust conference, where actually Ramsey was present, that's where I met Ramsey actually. The first question from the audience was from an antitrust law firm partner who stood up and said, I turned to the audience and said, who here doesn't want to be in the top 1% of households by income? And nobody raised their hands, and he said, okay, I rest my case. But what I'm saying here is that even if you're that law firm partner and think we shouldn't care about inequality, there are still efficiency and economic growth reasons why we should change consumer law to make it explicitly consider distribution. Finally, on whether consumer law can reduce overcharge, as one example, a few years back, Israel passed a law requiring grocery stores to make price data digitally available. Consumers started using price comparison websites that were powered by that data, and a follow-up study found that prices dropped on average by 4 to 5%. So in closing, there are reasons to believe that consumer law can substantially lower income inequality, in the process making markets more efficient and growing the economy. Thus, we should embrace more distributional and macroeconomic considerations, particularly those that might leverage the power of digital price comparison tools. More broadly, we need to reassess the long-held misconception that consumer laws shouldn't be used for distribution. Thank you, and I look forward to hearing the rest of the panelists and the audience.
Perfect. Thank you, Rory, for that wonderful beginning. Now, our next panelist is VJ, who will now speak to us.
Okay. Hello, all. What I'm going to talk about is somewhat related to what Rory talked about, and also to a question that Ramsey posed yesterday in his introduction, and that's why we don't see more distribution in consumer law policymaking or consumer financial regulation, even though resources in consumer financial markets are really unequally distributed. And one reason could be that consumer advocates and consumer scholars sort of fetishize markets and think that we should only intervene. We should only intervene if there's some sort of market failure, and so we can unjam the gears. But once we unjam the gears, markets will be able to deliver sort of safe and affordable products to consumers. Instead, what I argue is that I think the big constraint on solutions to problems in consumer financial markets is Kaplan and Chevelle, and the view that we really shouldn't use consumer law to redistribute income because it's more distortionary than redistribution through tax and transfer. So if you canvass that literature, if you canvass the critical literature of the double distortion argument, one, it's really extensive. And two, it has a really, I think, comprehensive critique of the double distortion argument. And among the recent critiques, there's sort of three, I think, important points. One is there's good reasons to doubt, good empirical reasons to doubt the assumptions underlying Kaplan and Chevelle's model, in particular that we should be really concerned about labor to leisure distortions in all kinds of redistribution, and with a labor income tax, we only have to worry about labor to leisure distortions. Two, we just don't redistribute income through tax and transfer at all. There's very little redistribution that actually takes place. And the third is Zach Liskow's point that there's real cost to pursuing efficiency without any redistribution. Because of the declining marginal utility of income, if the state's trying to decide how to allocate resources between rich and poor consumers, it may allocate those resources to rich consumers if it's operating within an efficiency framework. And then in a subsequent period, if there's no interperiod redistribution, that bias might grow sharper. So what I try to do is build on Liskow's work to show why I think it's a mistake to ignore distribution in consumer law. So in consumer law, the issue that we're confronting is deallocation or deregulation. So at some point in the past, there's been some deregulatory move, or the welfare state has shrunk in a way that new demand for really expensive financial products is generated. And this demand has the shape of has a shape that resembles what's known as inferior goods, where willingness to pay is inversely proportional to income. So as income decreases, consumers have more willingness to pay for these really expensive financial products. And that demand is clustered amongst really poor consumers. So you have these really poor consumers who are willing to pay quite a lot for really expensive financial products. There's almost no other demand for those products. And the second point is, even though these products may be really expensive, they could be priced at marginal cost because it's really risky to underwrite these loans, and it's expensive to underwrite these loans. So even though, let's say, a title loan has an annual percentage rate over 1,000%, that may reflect real costs. Okay, so if regulators try to intervene after this deregulatory move, they run into this initial objection that the intervention is going to be inefficient. And the main way we try to respond to that objection is to try to demonstrate that, no, it won't be inefficient because consumers are biased in some way, okay? And that's the only reason they're entering into these transactions. Maybe they're present biased or overly optimistic, or scarcity is pushing them to enter into these transactions that are really bad for them. But that raises a number of objections. One, there might be really thin evidence that they're actually present biased. Two, being present biased or overly optimistic may not be bad if that bias causes consumers to appropriately consume goods we want them to consume. And if we fix that bias and they don't obtain the credit they need to consume the goods we want them to consume, then that would be bad. And the third objection is, look, we all know there's going to be no redistribution. So if you intervene in this market, or we know there's going to be no redistribution through tax and transfer. So if you intervene in this market, the intervention is going to be regressive, because yes, you might help some consumers, but you're really going to hurt really poor consumers who have no alternatives. Fundamentally, I think this constrains our ability to intervene in markets, intervene in consumer financial markets, if we try to narrowly justify our intervention by some sort of market failure or cognitive bias, or try to tie our intervention to consumer preferences. So I think one example of this is the Consumer Financial Protection Bureau's multi-year effort to try to regulate the market for small dollar high cost loans. So right after the Bureau was created and started running in 2011, it turned its eye towards small dollar high cost loans and tried to create a national framework for a national regulatory framework for this market, which is largely unregulated at the federal level. That effort, after like hundreds of white papers, almost 1,000 pages in the Federal Register, we got this rule in 2017 that set some restrictions on the size and the features of short-term payday loans. Okay, but that rule was rescinded, the main reason it was rescinded is you had these Trump Republicans who came in and were really opposed to any kind of regulation of the payday market. But the formal justification for the rescission was this debate over the CFPB's use of some survey data. There was this argument that survey data, survey data showed that consumers really understood the costs and the risks of really expensive payday loans. They knew there was a high likelihood that they were going to initially default and that they were going to have to reborrow. There was no real bias that this intervention was solving, and so we shouldn't have intervened in the first place. So fundamentally, on some level, maybe there's not real lessons we can draw from this experience, because maybe the new set of regulators who took over during the Trump administration were sort of hell-bent on unwinding this rule, and this is really not a story about consumer preferences. But there was lots of sort of serious people who thought that it was misguided, and that we really shouldn't intervene in those markets. So I think fundamentally this is one illustration of why we should try to look for more expansive reasons to think about intervention in consumer markets, and we should try to center distribution. So what might that mean? Well, tying it to this conference, one thing that could mean, to Rory's point, is looking at producer surplus and focusing less on psychological impairment or bounded rationality, and looking to the ways that producers can sort of extract more in transactions. Another thing that we could try to look at is consumer surplus. So consumer surplus is a challenge in consumer financial markets because we have different products that are consumed by different people. Okay, and so there's no consumer surplus in the market for payday loans. But there might be inframarginal consumers in other markets. And so one idea is you could try to find consumer surplus by undoing cross-subsidies. Okay, so if you find that expensive products are cross-subsidizing cheaper products, you could use cross-subsidies to unwind those. You could use cross-subsidies to unwind, you could try to unwind this regressive cross-subsidy and take away some surplus from those inframarginal consumers. And more radically, you could actually try to look to manufacture cross-subsidies through mandates and transfers to try to take away surplus from some inframarginal consumers and use it to subsidize cheaper goods to other consumers. And so I'll stop there.
Thank you, Vijay, very, very much. Now we have Piran.
Thank you all, and thank you to Rami for the invitation, and happy and honored to be in this distinguished panel. I try to just share with you the screen. I hope it works. And here we go. Can you see that?
Yes, it works.
It works? Okay, great. So my name is Baran Kianzad, and I'm a PhD fellow at CIBL. I'm just going to adjust this a bit. There you go. What I'm going to talk about is excessive pricing during the COVID-19 crisis, and which was done as an empirical inquiry sent to competition authorities in EU. And after that, I'm just going to offer a very brief analysis of the results and then talk about the more normative issues which we are talking about and the role of fairness in pricing and what this means also according to Chauvel and Kaplo and some of those dynamics. So basically, I opted to do an empirical study targeted to competition authorities in EU member states, investigating recent reports of dramatic price gouging and dramatic price hikes of essential items such as face masks, sanitizers, and so on, which was also reported in the US and globally, also in South Africa. I'm going to talk just a bit about South African cases. This was done as an inquiry per email, and it was done between June and October, followed up by phone calls. And I sent them 3 questions. So basically, how many excessive price complaints has the authority received in connection with the COVID-19 crisis? Whether the authority already had opened any proceedings or considered doing so, and if there was any other general comments in this context. I should elevate the point that there are 27 different jurisdictions, and some of them combine competition law and consumer protection in one agency. So this kind of corrupts the results, but I've been mindful of that fact. And the study is published in the recent volume of Concurrences, just came out this Monday. And I'll be happy to send it to you if anyone wants to get more deep into details. So we had 23 out of 27 authorities responding, which is a quite okay response rate, I would say. Given the circumstances, they were quite busy with the crisis management. We can see the outliers here: United Kingdom, Poland, and Spain, but also Italy to some extent. And they received between 500 and 9,000 plus complaints, manifestly high in the case of United Kingdom. Also, Italy and France had received a number of complaints. They could, however, due to different institutional rules, not disclose the quantitative data, so they were not included in the tables per se. The second group are those who received few complaints, but still traceable, between 1 to 10. We had in Germany, Denmark, Belgium, and Austria receiving between 1 and 10 each. Also, Netherlands and Portugal reported receiving cases. However, again, not being able to quantify those, they were not included in the table per se. Going over to the investigations and cases pursued, also not all information could be disclosed due to confidentiality reasons. However, we could the data we could gather was that there were cases ongoing in Spain and Poland and Italy, and in Belgium, 1 investigation is still pending. United Kingdom pursued and closed investigations on 4 cases without finding any abuse. There were also some price regulation introduced in Malta, Croatia, France, and Romania, putting a maximum price on those designated essential items. Going just over to the analysis, we could see sharp price increases in price of essential items across EU and across the world. Those items being masks, sanitizers, but also related services such as funeral services. And this was in the beginning of the crisis in March to April of last year. Thereafter, we could see a decreasing number of complaints and also prices slowly returning to normal pre-crisis prices. Pricing regulations were introduced in some countries, but the authorities in EU did not rely on them per se. Some countries did pursue cases under consumer protection law, on fair pricing laws, and so on. And because those countries combined competition and consumer authorities in one. And there was also more cases noted in countries such as UK, Italy, and Poland, which was this case of a mixture of consumer protection agency and competition. And in the case of UK and Italy, which had just recently pursued very high-profile cases, excessive price cases, the high number could actually be indicative of the previous activity of the authority. So also when we compare this to the situation in the US and South Africa, which also pursued this kind of price gouging cases, US and South Africa, they put the emphasis on unconscionable and unfair aspects of the practices, regardless of the size of the undertaking and whether the prices return to normal levels. In order for the EU prohibition on unfair pricing as per Article 102 to be applied, the undertaking must be dominant in the relevant market. And US and South Africa, they also allow defenses regarding increasing price, but there was a manifest difference in this approach between these jurisdictions. And because EU, as said, treats the cases under normal excessive price regulation, and US and South Africa, they target price gouging with benchmark of pre-crisis prices, 10% in the case of the US, and in South Africa, there was a mixed approach. However, the theory of economic dependence and temporary dominance could alleviate and help overcome some of this enforcement analysis in the EU context. And however, in the general responses, EU authorities, they stress their commitments to pursue excessive price cases to be treated as an anti-competitive practice and as a matter of statutory duty. So, coming over to the main theme of the conference and the other panelists, when we talk about excessive pricing in law and economics, there is normally a huge pushback from the neoclassical, marginalist, welfarist, and Chicagoan literature on the subject. This is due to an inherent tension between the economics discipline, some part of it, the neoclassical version of it, and not the classical version by Adam Smith and Ricardo and so on. And this has to do with the elevated issues such as dominance, market power, and the assertion that prices are self-correcting when we actually know that they are not. It depends very much on the circumstances of the market. And it also had to do with the asserted role by these schools regarding the role of competition authority and price regulation. And these schools, they do not recognize fair in itself. They do not recognize economic value in itself beyond an exchange value, which is given by the market. And there's also this Borkian confusion of total welfare, which he called consumer welfare, which actually has nothing to do with consumer welfare per se. Furthermore, willingness to pay contracts issues of just price, which we have 2,000 years of history and rather solid legal tradition on that. And also equality in transactions, going back to Aristotle and coming forward to Aquinas and forward. Looking at the empirical issues, the assessment challenges are elevated by those aforementioned schools, the neoclassical and marginalist, and the finding of proper benchmarks and is amounted to an impossibility theorem, which actually do not hold up. Furthermore, it's asserted that a vigorous enforcement against excessive profits would chill investments and chill incentives. And it's also asserted that there's a lack of competence at competition authorities. There would be monitoring issues, and the calculation of fair profit would be also an impossibility theorem, which has to do with the intellectual inability of those schools with fair in itself and economic value beyond an exchange value. And there's also, in the literature, we have not found any causal relationship between increased profitability and increased investment innovation. Indeed, we can see the opposite. However, the COVID-19 pandemic might change these dynamic and assessments, or does it? Are we all Kantian and Keynesian now? I'm not so sure. However, we know now that the core assumptions of the welfarist neoclassical and marginalist law and economic schools, they are, to be put it mildly, worth revisiting. And this is the insights we know from Kahneman, Thaler, Solow, Krugman, Kaplan, Stiglitz, Ezraki, Gilo, and a host of knowledge that we know now from neuroeconomics, not only behavioral economics, but also neuroeconomics, which is much more forceful in its pushback against rationality assumptions.
Okay, Peter, I think your time is over. You have to make a final sentence.
Yes, I will close in 1 minute with the last slide. So basically, what I've been trying to do is to put the law back into law and economics, and this is also seen from the recent jurisprudence in EU. And there's a vast number of innovating paradigm-changing approaches to calculation and inclusion of fairness in competition law and economics in order to construct proper benchmarks. And these, beyond behavioral economics and neuroeconomics, we also have statistical modeling, big data, and AI regarding measuring and monitoring of prices and so on. And to close, we also need to look at the digital economy with zero prices and market concentrations, and try to reconstruct a new theory of value and new theory of harm. Thank you very much.
Thank you very much, Biram. Inge, you're next.
Thank you, Adrian, and thanks a lot also to Ramsey for organizing this event. I'm going to share my slides with you. So this presentation is based on a paper about consumer sovereignty and competition law. And the paper looks at practices of what I've called personalized exploitation. So an example you see here on the slide where Uber is reported to start charging what it thinks you are willing to pay for a ride. And it's also reported, for instance, that Uber knows when your phone runs out of battery, so that this is information that the company can use to charge you a price at a moment where you may be in extra need of a ride. So these are examples of personalized pricing, price discrimination, a bit following up on the excessive pricing discussion in the previous presentation. But there is also personalized exploitation that is not so much tied to issues about price. So here you can think of behavioral manipulation, where companies are using information on behavioral biases to steer consumer choices and to trick consumers in making decisions that they might not have made otherwise. And I think we're all well aware that these practices exist, but what I feel is underexplored in this discussion is the role of competition. And the main message that the paper aims to send is that these types of practices and these types of harm are also becoming harm to the competitive process. And why is this so? So in my view, restrictions of freedom of choice by dominant firms in the case of personalized pricing or behavioral manipulation, they also start to lead to because the manipulation of consumer decision-making does not only erode the freedom of choice of individuals, but it can also further weaken the competitive process in concentrated markets. Because instead of making active choices reflecting true preferences, consumers are tricked into choices that are already laid out for them by the dominant firm. And this enables the dominant firm to pursue its own commercial interests to the detriment of consumers who risk being exploited, but also to the detriment of overall competition, which is controlled by the dominant firm through the way it is really steering demand and steering consumer preferences. So the nature of the harm goes beyond harm to the interests of individual consumers that are already protected by data protection and consumer law in the EU framework. So there is also competitive harm here And this is why I think competition law should also have a role to play in addressing personalized exploitation. And you also see that boundaries between legal regimes, as they are discussed in US literature on the boundaries between antitrust and consumer law, no longer really hold up here, because it used to be the case that antitrust law is asked to remedy market failures that are external to consumers, so focusing on promoting availability of choice, whereas consumer law should focus on remedying internal market failures that are happening inside the consumer's head. But where dominant firms are manipulating the consumer's decision-making process, the scope of application of these two regimes really becomes blurred. And this is why I feel we are dealing with a novel type of harm here, which competition law or antitrust in the US should also have a role to play. And the paper claims that by putting more prominence to the objective of consumer sovereignty in competition enforcement could be a way to do this. So then, of course, the question is, how do we operationalize this notion of consumer sovereignty? And here you can see that these practices of personalized exploitation really challenge the existing competition concepts that we have. So if you look at market definition and assessment of market power, you can, for instance, see that in the notice on market definition of the European Commission in EU competition law, that a reference is made to a relevant market consisting of products that the consumer regards as substitutable. So there is this idea that there is one average or representative consumer, that there is one competitive price. But in case of personalization, these ideas no longer hold up, because different prices may be charged for the same product over a particular period of time. And it is interesting that the notice on market definition already refers to the possibility to define narrower, distinct market for a distinct group of consumers when they're subject to price discrimination. So a question that you can ask yourself is, if we take this reasoning to its extreme, whether we could see the existence of personalized markets where a few consumers would form a relevant market of their own, and whether firms could even hold market power over individuals for a certain period of time when they are, for instance, particularly vulnerable. So what the paper does not claim is that we should extend the reach of competition law to such an extent, because it would be very controversial, but that we do need to incorporate how personalization really changes the nature and the functioning of markets. And the paper proposes to do so at the stage of where we assess abusive conduct. So what would such a competition intervention for personalized exploitation then look like? So here the starting point of competition analysis is to look at effects on consumer welfare as a whole. And this also means that there is room for subsidization. So if a particular group of consumers is charged a higher price, this may not affect consumer welfare as a whole, as long as there is then a different group of consumers that pays a lower price. But what the paper tries to show is that in the case of personalization, this type of economic calculation of the consumer surplus is no longer possible because of personalization and the fact that offers can be very dynamic and change over the course of a day, for instance. So the paper proposes, in order to effectively address personalization, to move away from this idea of consumer welfare as a whole, and instead take a standard of personalized welfare for assessing anti-competitive effects of personalized exploitation. So the idea here is that the limit of the analysis of whether there are anti-competitive effects is by looking at the consumers that are affected. And the paper then goes into this conceptual discussion how to do this, and relies on the concept of vulnerabilities that is already used in EU consumer and data protection law. Of course, the question is, how do we really apply this in practice, and how does the intervention threshold then look like? And here I think, although this might sound a bit exotic. I think it is possible to actually do this in practice. And here the key threshold would really be whether there is substantial harm for those affected consumers, either in terms of the extent of the harm, the higher prices, lower quality, but also the nature of the harm. So if consumer preferences are really steered, for instance. So the outcome of this would be that the diversity of offerings is better protected, because the remedy in such a case is to ban the use of certain information for targeting if that information is really exploiting vulnerabilities of a particular group of consumers in such a way that this leads to substantial harm for them. And the main point I want to put forward here is that, of course, we already have data protection and consumer law to protect consumers in this way. And competition law could certainly take a stronger distributional role as well. But where I see the most added value for competition law is to also protect the competitive harm in these cases. And I think that this is an element in the discussion that is so far missing. So if you're interested in reading the text, the paper is forthcoming in the Common Market Law Review. And if you're willing to have a look already, please send me a message and I will be happy to share it.
Thank you.
Thank you.
Thank you very much, Inge. That was great. Luke, the floor is yours.
Hi, thanks, Adrian. And thank you, Ramsey, for the invitation and for putting on this really lovely conference. And thank you to my co-panelists for really engaging and fascinating analyses. So if I had known this would be more of a consumer themed paper, I would have presented a slightly different paper. But I would say that the thing that I'm presenting is part of an overall project of basically rejecting the framework that is common to a few of the papers presented here and elsewhere in consumer law and economic and antitrust law, namely the framework of using some version of neoclassical welfare economics to analyze those areas of law and trying to think through an alternative framework, through an alternative set of social and moral theories about how those fields work and how to think through what they're doing and what they ought to do. This, I should note, is a co-authored piece. My co-author can't be here, but he's, I would say, much more closely grounded in the history of political economy and all the detailed literature there. So, if I'm unable to answer any question, it's not because we don't have an answer, it's just because he's not here to provide the perfect answer to your question. So the project overall is to think about markets not as essentially spaces where rational welfare maximizers meet to produce surplus between each other, and through an emergent process, institutions emerge from exchange that enables people to do so, or rather institutions distort people away from those outcomes, but rather to think about markets as governed all the way down, markets as collectively constructed spaces that channel individual actions in different ways depending on how they're constructed, and that they're always in the process of reconstruction, which is itself a contested process. So there's always, in any given market, coordination and competition going on at the same time to greater or lesser degrees, and interacting in different ways. And actors are not, actors that come to a market with an exogenous set of preferences that then come to the market and maximize those preferences as best as they can, given the structure of institutions, but rather that markets are social, relational spaces in which people come to preferences, change how they understand who they are and how they interact with each other. Reorienting analysis in this way has a whole lot of upshots, and that's just very broad sketch of the sort of overall frame that I'm going to present a more detailed part of today. I've been working on separately, the reason I said I maybe should have presented a different piece is I've been working on a separate piece on why I think consumer sovereignty is an incoherent concept, and how we can think about consumer protection through a different lens. And I'd be happy to talk more about that further, but this paper presents a different part of the picture, which is more sort of directly relevant to competition law, which is how does market governance over pricing work? And in presenting our theory, we're bringing together two frameworks. One is a set of long-standing but sort of punctuated literatures on market governance that are across several different social science disciplines, heterodox political economy, especially of the institutionalist tradition, economic sociology, some anthropology, a lot of historical work on pre-capitalist and early modern markets. And then we're putting those frameworks in conversation with some recent work by Sanjukta Tapal on viewing antitrust as allocator of coordination rights and understanding markets as structured by coordination rights. And we're trying to, as the paper is titled, theorize market governance after coordination rights. So try to use the coordination rights framework to understand how law relates to how markets are governed. So let me be a little bit more concrete than that. So what is market governance? So begin from the point that stable price formation requires collective action. It is not an emergent phenomenon. It's because competition is a destabilizing process. Participants are always involved in some form of coordination to allow for stable expectations to form, which allows the possibility of pricing in a moving and dynamic system. And as the market participants coordinate around prices, the form of the coordination that they come to, it depends on, or is facilitated by, or enabled by, or enforced by, in varying degrees, the legal system. And so the legal system contributes to structuring the space of market governance and how coordination over price works. So just to, it's actually a relatively familiar concept to think about, for instance, contracts as rules between parties that are then enforced by the state. They can be enforced by the state, they can also be prohibited by the state, or just not prohibited by the state, and they can be then interact in the shadow of the law. And similarly, you can think about coordination within a market beyond contracts as operating in this way across a diverse set of legal areas. So why is, what is this need for stability that we're talking about? Businesses are going concerns that cover obligations as they come due. So for the most part, businesses face costs before they face revenue. They have to, obtain access to goods on credit, and they have uncertainty about how well their business will do at any given time. And they develop strategies to manage the uncertainty they're faced with, to manage orders, and take on costs, and to adjust pricing strategy to manage revenue. And so, rapid changes in anything, prices, demand, supply, can mean failure, even for a solvent business. I mean, it can mean insolvency, but it can mean even for a solvent business, if they can't meet obligations as they come due, it's failure. And that uncertainty needs to be managed in some way. Now, whether it means failure or not depends on access to credit and a whole number of other institutions, and that's important. But this view of businesses are essentially dependent on credit. They exist in a world of ongoing obligations that are time sensitive. So there's a number of implications of that, but one implication is businesses need a mechanism for maintaining expectations and preventing what has been called ruinous competition, what is sometimes, sort of derisively called ruinous competition. That's what monopolists say when they, are caught for their monopolistic behaviors. They want to prevent ruinous competition, but this is a real phenomenon because destabilization can result in massive business failure, which we may or may not think is catastrophic from a removed perspective, but it's certainly catastrophic for the businesses themselves. And it may be catastrophic from a social welfare perspective. But the point is just that businesses think it's catastrophic and they have to do something to manage it. And so this form of like what we might think of as relatively more pure competition where businesses are aggressively price cutting is going to result in failure. I mean, especially for high capital businesses, for businesses with high fixed capital costs, but not exclusively. And so this destabilization is actually always a temporary situation, and it always reaches a new settlement. Oh, I'm going way too slowly. All right, so let me breeze through a little bit. How does coordination rights fit into this? So basically, businesses are always coming up with some way of managing price setting. So this might be there's a certain standard price. This might be there's a certain standard process for creating prices, a certain way that cost plus pricing or something like that. How do coordination rights work? Well, the legal system facilitates this coordination by granting legal permissions either to an individual or a group of individuals or a deliberative body with some degree of authority to direct some element of the production, distribution, or commercial process. Coordination rights can be explicitly granted, right? So a corporation is an explicit grant of certain types of coordination rights. Property rights are explicit grant of certain types of coordination rights, or they can be implicit. So forms of coordination ongoing that a court allows or doesn't enforce against can be implicitly allowed. They can be vertical or they can be horizontal. And they are emergent across multiple different areas of law, although competition law acts as a sort of coordination rights, coordination rights are conceptualized through competition law because the pattern of coordination rights in any given market is reviewed by competition law. I see my time is up. Let me just say one thing very briefly to motivate this a little bit more concretely, and then we can move on. So this might all sound foreign and not all that interesting, but I think managing the upshot for markets that are taken to be, for instance, closer to the purely competitive market on the standard neoclassical framework, and to see how we view it through this framework might be helpful. So take stock exchanges. You can also take commodities exchanges. These are spaces that are often said to be relatively, pure spaces of price discovery, where supply and demand establishes prices. But we would say what they actually are is places of vertical market governance. The New York Stock Exchange is explicitly chartered by the state with the ability to set rules for how bids and asks can be put in, to act as an intermediary for not the stock exchange, but in commodities exchanges, to act as intermediaries for all transactions, to stabilize prices, to set circuit breakers, etc. Thank you.
Thank you very much, Luke. Hope we have time to discuss this further in the Q&A session. Now we're already it's already 4 o'clock here where I am, so we have to move on. I was asked. So first, thank you all 5 of you for providing us with such, I would say, really provocative and sharp ideas that certainly push us to think in ways that we're not usually accustomed to thinking. So now I was asked to comment and synthesize your contributions, and I have to admit that I have never commented on 5 such thoughtful papers together. But let me try to make 3 very broad remarks and then give you a chance to respond. And we have already a number of very interesting questions in the chat, so maybe you can take a look at these as well. So let's say the first point that I observed is probably a legal descriptive one. So we can ask, what are the assumptions that consumer and competition laws are really built upon? And we heard that the conventional account, which is based on the double distortion argument or the argument that markets are self-correcting, suggests that consumer and competition laws are tools to counteract market imperfections, not to distribute wealth. So consumer law corrects market failures internal to the consumer, and competition law ensures that markets remain competitive so that consumers can choose between a meaningful range of options. And everything that has distributive ramifications is left to the tax system. And this includes correcting for behavioral manipulations that go beyond issues of information asymmetry or information failures that enable consumers to make welfare maximizing decisions. But it seems to me that the panel seems to view behavioral manipulation as problematic precisely because they have the potential to perpetuate or even amplify negative externalities. And Rory calls this overcharge. Producers engage in consumer overcharge based on manipulation. So we may refer to this phenomenon as behavioral overcharge. Now, if behavioral manipulation is the basis for much of what we see in our current debates about the function of consumer and competition laws, this reflects a shift in argument from a strict efficiency point of view to concerns about inequality, fairness, sovereignty, and for how we institutionalize and structure markets, because they are no longer thought to self-correct. So in a broad sense, if we are concerned about behavioral manipulation, the issues that we are talking about are really issues about advertising. And advertising has long puzzled scholars of consumer and competition law. For instance, if we take the model of perfect competition as an analytic starting point, advertising serves an informative function. It helps buyers to quickly find what is to be acquired. But if overcharge becomes our concern, advertising must be viewed not only to inform, but also to persuade. Producers extract more surplus from consumers than they otherwise would. So we can therefore either treat all advertising as information, and here we would think that if consumers purchase advertised goods, this is proof that advertisers have appealed successfully to their pre-existing wants, or we can treat all advertising as persuasion because manufacturers and sellers systematically take advantage of individuals' psychological weaknesses, and this brings about untenable degrees of manipulation. But there seems to be an alternative path, and that seems to be at the core of what the panel suggests. We can try to demarcate in one way or another some positive and negative market effects of advertising or manipulation. And there may be very good reasons for doing so, particularly as we heard in times of crisis or in the digital economy. So if we, for instance, think about personalization, users of a social networking platform such as Facebook may view poor personalization as a problem, while poor data privacy could also be conceived as one. And these issues may even be mutually incompatible. So the question, I think, is really whether the discussed practices of market actors sit somewhere in between information and persuasion, and whether we can sensibly draw a clear line between them. Now, the second point is perhaps a predictive social science one. The question is whether consumer and competition laws are actually working to achieve their stated goals. Now, it looks as if the predominance of the double distortion argument has led consumer and competition law analysis to be governed by a fairly narrow set of methodological approaches that sometimes suffer from critical blind spots. So the growing interest by the panel in greater methodological pluralism, particularly in research from behavioral economics, from macroeconomics, or even from labor economics, illustrates this point. But each of these approaches is likely to generate at least some contradictions. For instance, if we presume that on the whole, consumer and competition laws have been designed to counteract information asymmetries and market failures to achieve efficiency, in reality, enforcement of these laws might still have wealth distributive effects. As Vijay and Birang point out, someone might reasonably be willing to pay for a small-term, high-cost loan or an overly expensive mask in times of emergency, although the same person would disagree to conclude the same bargain in ordinary circumstances. So willingness to pay values or consumers' choices as we find them may be the result of a particular decision-making context and may therefore not always relate reliably to their intended or predicted welfare effects. Or another contradiction relates to the enforcement of these laws. If overcharge is unevenly distributed amongst those who consume and those who produce, equal enforcement of consumer and competition laws might inexorably exhibit redistributive effects. So poor consumers who spend a higher percentage of their income than others on behavioral overcharge will disproportionately benefit by an equal reduction of overcharge. So in all these cases, we may have proposals that reflect legitimate but opposing goals. Targeting overcharge may be a defensible, if controversial, policy choice to the extent that it avoids viewing competition as an end in itself, and instead as a means for preserving economies of scale, while at the same time preventing exploitative practices that monopolistic control allows. Similarly, as we heard in the context of workers or small enterprises, permitting coordination through labor laws or antitrust exemptions can bring about forms of organization that are critical for innovation and growth, but may contradict the goal of maximizing efficiency. So the question, I think, is whether we should focus less on one single theory or conceptual framework and engage more thoroughly in empirical questions, which may need to become a key facet of our scholarly agenda. And the third and final point, I think, is normative. So the question is, how do we evaluate what the law should actually do? Now, the panel seems to suggest that the conventional price theoretic framework is not always rich enough to deliver a satisfying formula to do justice to an increasing amount of advertising or behavioral manipulation. So a critical debate might refocus consumer and competition law on actual business realities. So this does not mean, as we heard yesterday, that we should miss the benefits of a unified and coherent methodology. But a stated commitment to scientific inquiry also suggests that we constantly revise existing theories and assumptions in light of new empirical evidence. So in that sense, the contention by the panel, I think, is that no single principle or set of principles can play a definite role in consumer and competition law analysis. Rather, enforcement of these laws must be contingent, with rules and doctrines being justified by the interaction between a multiplicity of theoretical and empirical findings that may sometimes reinforce and qualify each other and sometimes defeat or cancel one another out. For instance, current enforcement of excessive pricing practices is clearly shaped by price theoretic considerations, but as Inge observed, also bears the mark of other concerns, such as the prevention of exploitation, manipulation, fairness, and so on. I think it is difficult for anyone who pays attention to the actual practice of consumer and competition law to deny the relevance of these values in particular setting. So my very broad question to the panel is, are these fundamental contradictions inherent in the very idea of regulating, or indeed, as Luke points out, not regulating the economy? Help me reconcile these observations with your own reflections, particularly with the fact that we have all of these challenges existing, which are real in our institutions and practices of government. Do we have to model markets less top-down to try to identify the conditions under which competition is optimal, but instead to proceed more often from the bottom up in order to reinterpret actual consumer behavior and to develop some greater sensitivity to the real-world impact of corresponding rules and doctrines? Help me reconcile these observations.
Well, so is this open? Okay.
I open this to the whole panel, so you can just respond, because these are some commonalities that I observed in your presentations, I think.
Well, so I guess maybe one response might be sort of a provocation, which is if we think algorithmic pricing and highly targeted, whether it's pricing practices, advertising practices, distribution of goods, provides empirical evidence that the sort of neoclassical model of preference maximization and advertising as either furthering preferences or changing preferences, and therefore is manipulative in some sense. If we think this is evidence against that, why do we think it's evidence that that was the proper theory beforehand, right? Why is it that we've, I think it's often conflated, the empirical evidence against neoclassical economic welfare economics within consumer markets is often treated as a recent development in the markets themselves, that they somehow have moved away from the world in which the model was actually accurately representing the market. And I guess I just wonder the degree to which folks think that is true. Is it that the model is better when prices are more uniform? Do we think that people are actually maximizing exogenous preferences just because there's not algorithmic pricing practices? And if it's not, right, if empirical evidence is providing a reason to think that that version of the model isn't true, then is it the model itself that's a problem, or is it just that we need to, develop more sophisticated versions of it to make sense of how consumer choice works in the present?
I mean, the question is also, and this question was raised in the forum, in the chat already, so very broadly many times, whether we talk about excessive pricing practices or consumer arbitrage in consumer law itself, how do we actually determine, and Rory pointed to studies and how this demarcation was made between markups that should be allowed or markups that should be banned, so to speak. So when is a price excessive, and when is it a legitimate result of a business profit? And I think that's exactly the problem of the entire discussion. Yes. You can just jump in, Biran.
Okay. Well, the topic of my PhD thesis is how much is too much. So I feel compelled to say at least a word about your last question. First of all, I think we must look at the normative and intellectual content of some of the theories discussing excessive pricing. So if you look at the normative and intellectual content of neoclassical, marginalist, and welfarist theories, they have no intellectual content in relation to when and how a price can ever be excessive and unfair. You will never find any answer in those theories, because they deny and value a fair price in and out of itself. So we have nothing to gather there. If you have a look at some other theories, with having a bit more of intellectual curiosity, they have looked at what do people consider a fair price in transactions. We have some legal history indication going back about 3,000 years in Jewish law, in Islamic law, in Christian law, in scholastic thought, and so on and so Roman law, and so on and so forth. There is one consistent law about market and trade, and that's the law against undue profiteering, usury in the Bible and in Jewish halakha, and so on and so forth. Right? This is the most consistent legal economic finding you can find throughout the history. So why do we have an aversion against unfair pricing? Well, we know that we have an aversion thanks to the work by Kahneman and many others. We also have neuroeconomic studies now showing that when people play the ultimatum game, the area of the brain calculating for utilitarian objective is not activated. The area in brain considering values and fairness is highly activated, much to the dismay of the neoclassical compatriots. So, can we find a proper benchmark is the golden question. Is it a legal question, or is it an economic question? Or is it a legal economic question? Because I have three different answers. So legally, yes, we have a jurisprudence finding the benchmark. Is the benchmark correct? Is the economic criticism, And we can supplement that with the theory of dual entitlement. But also, when you look at the markups prevailing in the sector, if you have a sector, you have highly profitable and highly efficient undertakings active in a sector which is not monopolized or plagued by state monopolies or other devices, right? You can find a proper return on capital, a proper return on investments. You know, there is that to be found. If you are an investor, for example, if you, for example, today want to go online trading, you know, and just invest some money, there are a host of financial instruments free online, giving you the benchmark in the prevailing in the sector, the benchmark for the company examined, and so on and so forth. So yes, we can find a proper benchmark. However, if this is acceptable for a theory which does not accept economic value in and out of itself, or that it can ever be something called unfair pricing, well, there's, you know, you can do how much benchmarking you would like. You would not convince the people who are convinced otherwise. Thank you.
Thoughts, comments, reactions? I mean, we have a Vijay, in your context, which is more about financial markets. You observe something similar. So there is demand for inferior goods when we simply look at consumers' choices or willingness to pay values. The question is really, how can we keep sight in policy debates of like these unintended wealth distributive effects or negative externalities that you describe? So,
so I don't know. I'm less. I think I agree with Luke and Bering. I'm sorry if I got that wrong. I think that I'm less sanguine about behavioralism. I think we sort of, so in the things that I think the most about, which are expensive financial products, I think that those prices are constructed. I think it's quite clear. And so Luke talks about coordination. Maybe that's a bit abstract, and maybe we're not convinced that that always holds, but it definitely holds with really expensive financial products. And so the prices are just, either the prices are set by the state, and so the state will set a usury cap, and then everybody in the market will charge that price, or there's no cap, but market participants will sort of coordinate and come up with a uniform price, and there'll be some margin of error and or some small degree of difference between different lenders in that market, but they'll generally be within the same range. You know, and then, I mean, if you're operating within a neoclassical framework, an efficiency framework, a law and economics framework, I think that you'll argue that that those prices aren't coordinated, and those prices reflect revealed preferences and the marginal cost of providing this good to really risky borrowers. But I think that's likely not true. And then I'm just not convinced that we can change their mind by showing that there's behavioral bias. And so instead, I think that I think it's okay for, in markets that are really heavily constructed, and maybe all markets are constructed, but I think that law really shapes demand in fringe financial markets. And so I think we should feel comfortable setting prices and not using sort of some market mechanism to figure out what that price is, but just sort of declaring what the price is and then trying to figure out how we can deal with some of the costs of setting that price.
Yeah, well, this is great. I mean, this also relates to the kind of the demarcation, which was also a question that was raised in the chat. I think this relates to Rory's and Inge's presentation. So how do we actually demarcate between consumer and competition law? Are they the appropriate tools to address, let's say, wealth distribution and so forth? I mean, traditionally, we would say this is one view, that consumer law tackles deception, like false statements, outright false statements, while antitrust addresses collusion and exclusion and so forth. But maybe in today's economy, digital economy, non-price markets, the risks of manipulation are perhaps more subtle. So they may reside in the power, and you alluded to that in both of your presentations, the power that some firms possess in bringing certain information to your or to our attention. So we might need novel solutions to tackle with these sorts of manipulations. What are your thoughts on this?
Thank you for bringing up this point. I think I often have the feeling that we are very stuck in thinking about, or from the perspective of existing legal frameworks, existing theories. And I think, of course, we need to do that. But I often think that sometimes this also restricts us in our thinking. And from my perspective, it's also really important to go back to what are the values that we want to have in our economy, in our society. And you, Adrian, you referred in your comments also to this idea of should we take a more top-down or a more bottom-up approach. I guess the problem is how do we find a good balance? And on the one hand, I think we should really go back to how consumers feel in markets, because it's often difficult to figure out exactly whether consumers are really truly empowered or whether they are just they just feel empowered, but in fact it's a firm that already lays out the choices for them. So I think these are really key challenges for which we need to be also maybe a bit more creative and feel less bound by existing notions, by existing frameworks. So I saw one question in the chat, for instance, asking about what is the limit of exploitation in competition law? And I think here for me, I would take a very broad interpretation of that. So indeed not being bound by the more stricter interpretations that some have about EU competition law, that exploitation only matters when it strengthens the existing dominance of the firm. So I think for me, it is really about how can we make the values that we think are important more effective. And of course, this is a substantive question on how we should interpret the rules. But in the end, it's also an institutional question, which should be the authorities put in place in enforcing the rules. And this is a question that we now also really have in the EU, where we see a lot of new legislative proposals being published, the Digital Markets Act, the Digital Services Act. But you also see a move towards more stricter regulation and more novel ideas about how to regulate these markets. And from a substantive perspective, this requires new rules, but it also requires effective institutional frameworks and effective enforcement strategies. And I think this is an important part of the discussion that also really needs to be fleshed out more.
Yeah, even though I'd like to see, I think those are all great points. And even though I'd really like to see a broader conception of consumer laws encompassing parts of antitrust, I think there's some rich interplay and potential for greater harmonization of those two kind of fields or areas of study and law. I'm not too motivated by boundary drawing exercises. I also don't really see the ideas discussed by the panelists as too much in tension. I see them as different opportunities instead, different ways to address a similar fundamental issue, which is that there's good reason to believe that markets are not distributing as they ideally would. And when behavioral economics came along, the response by many neoclassical economists was that it wasn't a new paradigm, that it didn't change the broader framework, and that it fit quite nicely into existing kind of economic theory. And regardless of the answer to that, there are shortcomings in the existing price market paradigm. And there are many different ways that we might want to move forward, many different potentially appealing paths forward, or at least worth experimenting with, because we've been on a similar path for a long time. But some pretty clear, the one thing that seems pretty clear to me is that there's a need to consider distributional implications more explicitly in markets, regardless of where you're, like, what theory you're operating in.
I might say, one. Sorry, are we out of time? did you? Okay.
No, actually, I want to follow up on you with that, but it's perfect. Yes.
Okay, so what I was going to say is that, you know, one thing that maybe provides a connective glue, even if we somewhat disagree about framework, is that I think that, like, one of the ways that economic analysis has been able to manage its internal, I would say, contradictions, but tensions, is by attaching itself to existing doctrinal frameworks and sort of using its framework to interpret the frameworks. And so it's still often tied within frameworks within existing markets, including, you know, both in Europe and in the United States, fairness is a norm. It's explicit, you know, unfair acts and practices, unfair pricing, et cetera, are norms. And so economics has to say, what does that mean? Now, of course, they have a whole social wealth, you know, they have a whole notion of how that norm fits within a broader, you know, set of institutions that's optimizing a social welfare function, et cetera, et cetera, et cetera. But, you know, they still have to make sense of that norm in some sense. And so focusing on that law and interpreting how that law sort of guides our moral analysis might allow us, you know, when we say things like distributed things matter, we might interpret that in slightly different ways, but at least we have some common ground and we can work out, you know, case by case and doctrinally, and maybe there's going to be overlap there.
Perfect. I mean, so I was just going to say, and maybe we have time for one last comment by each of you, that these discussions, of course, also taking place against the backdrop of a broader law and political economy movement, Luke, that you allude to, and that is kind of interrogating how laws that structure markets in our economy can be reconstituted to promote more, let's say, democratic ends and so forth. So we can ask, what are the main legal reforms and interventions that this program proposes beyond competition and consumer law? I mean, the question is, do they also include renewing labor law and protecting workers' organizations, reinvigorating public utility regulations, or adopting public options to achieve these goals of rebalancing power and checking private domination? Maybe one brief comment by each of you, and then we're already out of time.
Say yes. So there was a comment about appropriate tools, and I think that we should soften our concern about what tools are appropriate and be open to sort of using a richer toolkit in different areas, and that could be in labor law, consumer law, antitrust. And then there may be questions about, you know, once we have that richer toolkit, should we sort of use those tools in this particular situation? I'm sort of open to that, but yes, I think we should use a richer set of tools across domains.
So for me, I think apart from a richer toolbox, I think we also need to create more opportunities with the regimes that we already have. Think in how we can strengthen different regimes by making use of their synergies more. And apart from this, you mentioned public utility frameworks. I think you also do see a move towards more what I would call pro-competitive regulation, which was also the initial title included for my contribution. And I think this also shows that the boundaries between the existing regimes are really becoming blurred, and that we're also thinking more about how can we not really restructure markets, but how can we put values that I think have traditionally been always at the basis of how we think of our society, how can we put them back in an era where, for instance, especially in the digital economy, we see firms actually taking over markets and taking a lot of control over how public interests are enforced. So I think that is also a move that you see where it's not only about the boundaries between regimes and making use of interactions, but also promoting the old values that we have through new types of regulation.
I'll just quickly say that you know, it's hard to argue with the pluralistic approach to distribution, but I also think it's important to not to lose sight of the potential magnitude of what each area of law can accomplish and the nature of the benefits of intervention using that area of law. And I may be behaviorally biased, but I think consumer law, including antitrust, is one of the most attractive levers that the law offers.
Good, thanks. Ramsey is here, so we're over, and I would say a big thanks to our panel for this very inspiring and encouraging conversation. A round of virtual applause for everyone who participated, who submitted questions, and who spoke to us, and Ramsey will give you a heads up.